Get ready for the dictation in 3, 2, 1, start. That in the case of Paramjeet Kumar Saroya versus Union of India and another, rendered in civil writ petition number 7282 2000, the Honorable Punjab and Haryana High Court had an occasion to examine Section 17 of the Maintenance and Welfare of Parents and Senior Citizens Act 2007, which prohibited representation by a legal practitioner in the context of Section 30 of the Advocates Act. After examining the said Section 17 of the Maintenance Act in light of Section 30 of the Advocates Act, the Punjab and Haryana High Court held that Section 17 of the Maintenance Act would not come in the way of legal representation on behalf of parties post 15/6/2011 in view of Section 30 of the Advocates Act having come into force. The Honorable High Court observed as under. In the conspectus of the discussions aforesaid, we are thus of the view that the decision wide Section 30 of the Advocates Act has become law on a posterior date to Section 17 of the said Act, which is sufficient for us to come to the conclusion that there cannot be an absolute bar to the assistance by legal practitioners to a tribunal or the appellate tribunal, despite the notwithstanding clause. Both the enactments are central enactments. While the said act was being enacted, the absence of Section 30 of the Advocates Act was known. Not having conferred that right under Section 30 of the Advocates Act on the legal practitioner, the Parliament, in its wisdom, had found no reasons to give such rights under Section 17 of the said Act. However, the situation has subsequently changed on account of Section 30 of the Advocates Act having come into force. The right conferred under Section 30, subject to the provisions of the Advocates Act, is on every advocate so far his name is entered in the state roll to practice throughout the territory to which this act extends. Such right is qua all courts including the Supreme Court. Such right is also before any tribunal or person legally authorized to take evidence. Thus, if a tribunal is legally authorized to take evidence, there is right in the advocate to practice before the tribunal. The tribunal has the right to take evidence. That being the status of the tribunal, there has been intrinsic right in the advocate to practice before such tribunal in view of Section 30 of the Advocates Act, which cannot be taken away. The position would be the same before the appellate tribunal in view of the powers conferred on a tribunal constituted under Section 7 of the said Act. Section 6, 8 and 11 of the said Act leave no manner of doubt about the vast powers, including taking the evidence on oath, enforcing attendance of witnesses, compelling discovery of documents, it being a civil court for all the purposes of Section 195 and Chapter 26 of the CRPC, etc. the overriding provisions of the said Act under Section 3 in the context of Section 17 of the said Act have to be appreciated in the context of the law prevalent when the said Act was enacted. Stop. The ground reality has changed on account of Section 30 of the Advocates Act having come into force on 15/6/2011, while all the judgments taking contrary view are based on Section 30 not being notified and the consequence thereof. Stop. Section 30 was not law when the said enactment was enacted and brought into force. Stop. Para. Further, the Honorable Punjab and Haryana High Court held Section 17 would not come in the way of legal representation on behalf of parties post 15/6/2011 in view of Section 30 of the Advocates Act having come into force. Stop. The copy of the judgment and order dated 28/5/2014 passed by the Honorable Punjab and Haryana High Court at Chandigarh in the case of Paramjit Kumar Saroya versus Union of India and another in CWP number 7282/2010 reported in AIR 2014 Punjab and Haryana 121 is annexed herewith as Annexer P3. Stop. Thank you.